Welcome back to this final session of our two-day conference, really a two and a quarter day conference. We started on Thursday evening with an opening address by Steve Hayward, who's now at the University of California, Berkeley. We've had great attendance and great panels, great conversation, and we expect our last group to live up to those standards. So I'm just going to briefly introduce again Mike Liburdi, who is a proud Arizona State University alum of the Sandra Day O'Connor College of Law, and is an adjunct professor of law here at the law school. And he's also the general counsel to the governor of Arizona, Ducey, and he in turn will introduce the other panelists. So please join me in welcoming our last panel.
Thank you, Paul. On behalf of Governor Ducey, to all of you from out of town, welcome. It usually is a little warmer in Arizona this time of year, so if you brought your golf clubs, you could probably make your way through 18 holes, but stick around. It's very nice weather. So the three panelists here with me. To my immediate left, Larry Alexander. Larry is a professor of law at the University of San Diego School of Law, and there he teaches criminal law and constitutional law. He is also a graduate of Yale and Williams College. And then to Larry's left is, physically, maybe not politically, is Eugene Volokh, who is a professor of law at the University of California School of Law in Los Angeles. There he teaches courses on free speech, on torts, religious freedom, and other subjects. He clerked for Judge Alex Kozinski and Justice Sandra Day O'Connor on the United States Supreme Court, and he is a graduate of the University of California at Los Angeles. And I just want to mention briefly that one of my favorite professors, Jim Weinstein, in the back there, he informed me of this great blog called the Volokh Conspiracy in law school, and that must have been in the year 2000 or something like that. So I've been reading you ever since.
I hear you say that.
And finally, certainly not to anybody's left, is James Manley, who is an attorney at the Pacific Legal Foundation and a senior fellow at the Goldwater Institute. His litigation portfolio includes cases that aim to protect free speech, economic liberty, and taxpayer rights. He is a graduate of the University of Colorado and Arizona State University. So there are our panelists. We're going to begin with Larry Alexander.
Thank you, Jim. First, I just want to thank the organizers of this event. Paul, Carol, Jim, Stephanie. It's been a really impressive event that I probably will produce a decline in the impressiveness of the event, but I have been very impressed with the entire event, the speakers who preceded me, the organization of this, and the facility and the program. It's been a real pleasure to be here. It's been edifying to be here. Somebody referred to the previous panels as an intellectual feast. I'm afraid I'm going to put us on intellectual diet here, but I will do my best. The topic, Jim Weinstein asked me to fill in on this panel, dealing with legislative remedies for the free speech issues on campus. And it's not something, if there's a wheelhouse of my expertise, it's not there. So I'm always nervous about legislative remedies that pertain to universities. I think one should be very, very cautious about promoting legislative remedies for whatever the ill is on a campus. Nonetheless, there are ills, and I'll get to some of them in a moment. First, just in terms of what schools can do with respect to speakers and speech. And I wasn't here for Robert Post's keynote yesterday, though I've heard Robert on this topic before, and so I think I can channel what he would have said. He would have maintained the distinction between academic freedom and freedom of speech in the constitutional sense, and I agree with that. A school, a university, as far as I can see, would be within its rights to ban all outside speakers or invite only speakers that are there to further a particular educational mission of the school. That would be within the academic freedom of a university, and it would raise, as far as I can see, no free speech issue. So you don't have to, a university does not have to have outside speakers. It can try to control the entire intellectual intake to the extent it can of its students. One thing, though, that a legislature can do, and I hesitate to even mention this because it treads on dangerous ground, but it can look across the domain and ask whether the departments in the university are adhering to disciplinary standards. I think it is fair to say that there are some things that count as departments within universities that I do not think adhere to any particular disciplinary standards. They are ideological, polemical, not academic. And a legislature would be, I think, entirely within its rights to refuse to fund such aspects of the university, even though they are on a campus, even though they may be populated by people who have some sort of academic rank, some sort of academic stature. They are ideological departments rather than academic ones. I realize making that distinction is tricky and fraught, and for that reason, I think it's, the suggestion I just made can be a dangerous one. But I do think there are such aspects of universities, and I think, although we would disagree about which ones they are in some cases, I think we would also agree on some of them. And since they are not furthering the academic mission, but are furthering an ideological one, I think legislatures would be surely within their right not to fund it. More interesting, I suppose, is if they're a public university and these departments are operating as I just suggested. Is the public now, because it is funding these departments, is it engaged in ideological speech? And this sort of gets into an area of the First Amendment, which, if you thought there was a lack of clarity in First Amendment doctrine in other areas, when you get to the government speech area, it's not just that there are a lack of bright lines. One has a hard time identifying whatever lines there are. So one question is so I said the government, the government would be perfectly within its rights to refuse to fund them. But if it doesn't, if it instead funds them, has this government speech crossed some sort of constitutional line? I always, when I get to this topic in course in constitutional law, I distinguish, excuse me, between the government taking a position on, we're for or against climate change measures or abortion, life, various things that governments take positions on, and not just with speech, but with funds, with money. But one thing that would seem to cross the line, for example, is when the government funds, the government takes out public service ads saying, vote for Jim, or vote for some, vote Democratic, vote Republican. That's got to be crossing a line. And so then the question is, well, what's the difference between the government endorsing policies A, B, and C, and endorsing the candidate who's in favor of A, B, and C? There's a line there, and the reason I bring this area up is because one way of looking at public universities that are not adhering to academic disciplinary standards but are ideological is that you have the government, in a sense, speaking through these ideological departments. So there's a government speech issue. Even if a university has a policy against outside speakers, another question is, to what extent can the university police inter-student political speech? The bull session where students take positions, and other students might be offended by the positions they're hearing their fellow classmates. I don't know of any university that tries diligently to stamp out inter-student speech, but I assume under the guise of harassment or other kinds of breaches of protocol that some students might get sanctioned. I would think, again, if it's well understood that when you come to this university, there'll be no free political speech outside of the, outside. You have to keep mute while you're on the campus. Wouldn't be a university that I think most people would want to go to, but I'm not sure there's any violation there of any speech. Again, I don't know that the legislature has to fund such a university, and probably shouldn't, but in any event, I think legislature can look at what's going on in the campus and make judgments about whether academic disciplines are being adhered to or not, and make a decision about whether they should, they may fund such enterprises. I want to turn though to the issue, that's more general because it applies to most universities, and this is universities that allow student groups and others to invite outside speakers to the campus. First, we heard some today in the previous panels about public fora within the university, on the streets that run through the university, on the commons ground and so forth. As far as I can tell, under free speech doctrine, these are public fora that can, where speech is to be as free as it is generally in the rest of the public. So that, raises no particular problem in terms of universities. The issue that has, of course, become newsworthy is what to do about invited speakers. And so here, and you've heard this before, the university has to, if it allows student groups to invite speakers, and it allows them to invite speakers for reasons that have nothing to do with furthering the educational mission, but just because the students are interested in politics or something else and they just want to invite speakers, then the university has to be content neutral with respect to those groups. It has to, if the Democrats can invite a Democratic speaker, the Republicans can invite a Republican speaker, and the university cannot take sides in terms of allowing one group but not the other to invite speakers of their choice. So, working to the hard problem. And the hard problem is this. So assume the university is neutral. It allows groups to invite whomever. But there is a danger of disruption. Not the polite, not the heckling in the House of Commons, but the kinds of disruptions that threaten to essentially shut down the speaker, not allow the audience to hear the speaker or to hear much of what the speaker has to say, and the like, the kinds of events we've seen. My approach to this, and I differ from Jeremy in this. I view this as akin to the way we deal with nuisances, where somebody is trying to have a conversation and their next door neighbor is playing really loud music, and you can't have a conversation at your dinner table. I view, this is nuisance behavior. I think that the university has an obligation to prevent the nuisance behavior. So if one group has invited a speaker, they're entitled to hear the speaker. And if they want, they can have a question and answer period or not. They can have ways of interrogating the speaker or not. It's up to them. It's up to them. And the university has an obligation to protect the group and its choice of speakers, and to allow the speakers to be heard without interruption, if that's what the group wants. But here we get into the difficult, what I think is a really difficult issue, which is that protecting the speaker and the group is not resource free. It, as we know from what Berkeley had to spend, it can be a serious resource issue. And free speech, for the most part, in American law, is an immunity. It's an immunity from government regulation. It's free in that sense. Free speech only requires the government to stay its head and not regulate. When you get into the issue of the heckler's veto and the like, you move from an immunity to some sort of claim right. to some sort of claim on resources to be protected, to be allowed to be heard. And part of the genius of the American Constitution is that it has very little of that in it. Most constitutional rights are immunities. They're prohibitions on the government doing something. They're not claims that the government must fund something. The one exception, the most notable exception, is in the area of the right to counsel in criminal cases, where you now have some sort of a claim right to a resource. It's an interesting area in itself. Even there, if the government can get rid of the resource issue by just deciding not to prosecute you. But in this area, in the heckler's veto area, I don't see any way of escaping the resource issue. So the legislature then, it has a limited budget. Any money that goes to protecting speakers comes out of some other place. Either the police are not, tracking down burglaries, or the money's coming out of the hospital budget or the education budget or something. Money is limited. Resources are limited. So how do we deal with the resource issue, the claim and what we don't want is for students to be able to make themselves such a nuisance that they can shut down speakers by just virtually making it too expensive for them to be invited. That would be a good heckler's veto right there. So, first thing that a university can do, and a legislature should demand, I suspect, of a university, is that if it is students who are disrupting, are threatening to disrupt, students are disrupting a speaker, they should be sanctioned by the university. They should be threatened with suspension, expulsion, something of the sort. That probably will be very effective in terms of the heckler's veto, where the hecklers are students who just disagree with some other student groups speaking. That doesn't deal with the outside disruptors, who are not students, and therefore now we're in the realm of law enforcement. There's a very nice little piece that was just written by a friend of mine, Fred Schauer, on the heckler's veto and the resource issue. And unfortunately, Fred didn't come up with any kind of good test for this, and I don't have one. Clearly, universities cannot be asked to shoulder the entire burden of policing events such as what happened when Antifa went on a rampage in Berkeley, for example. The resources have to come from elsewhere, from the city, police, maybe multi-jurisdictions, who knows. That is a problem because those resources are limited as well. I have no answer for that. I'd be glad to hear what answers other people might have. But as for now, I think that's the big problem, and I don't see what the legislative solution is other than spending more money.
Well, thank you, Larry. James has a legislative solution.
It's a great.
You want to talk about it?
Yeah. So, with my colleagues at the Goldwater Institute, with Jonathan Butcher, who's now at the Heritage Foundation, and Stanley Kurtz, who writes for National Review and is a fellow at the Ethics and Public Policy Center. The three of us drafted some model legislation that's been adopted in North Carolina. The University of Wisconsin Regents have adopted it as policy, or adopted a policy that's informed by our model bill. And then it's being considered in about a dozen states right now, including Arizona. And I think Eugene is going to offer some criticism of the Arizona bill. It's not my fault, though, that legislative drafting is a messy business once you get down to the Capitol. So anything that's wrong with it is not my fault. But the panel is about whether legislative solutions are compatible with academic freedom. And I think it's not only compatible, but essential. Because the Enlightenment values that we've been talking about, free speech, free thought, are under attack by the shout-down mentality. And Professor Waldron, to some extent, defended at least the thoughtful heckler last night. But I think it's wrong that shouting at each other is discourse, and I think it's wrong to say that dialogue requires us to abandon decorum. And our goal with this legislation is to restore free expression as a living tradition on campus, to restore the free exchange of ideas, to ensure that exchange is protected. And I think we can do it if we take those values seriously enough that we choose to defend them. And I think legislatures, especially state legislatures, have a duty to ensure that state institutions like public universities are respecting those values that we've enshrined in our state and federal constitutions. And so the Goldwater bill protects free expression for everyone on campus, for invited speakers, for protesters who want to ask tough questions and present alternative arguments at the appropriate time, for students to hand out literature or collect signatures on campus, for you and I when we're on campus having a robust discussion, and for terrible ideas, ideas that we all disagree with. Because, of course, the point of having free speech protections in a constitution or in law is to protect unpopular ideas. We don't need a First Amendment for ideas that we all agree with. We need to protect minority views, even and especially if those views are repugnant to most people. And I think that's especially true at the university because the soul of the university is the free exchange of ideas. And so it is a place to think the unthinkable, to question, and to have a competition of ideas. And when you disinvite a speaker who is too controversial, or you have speech codes that diminish the range of acceptable topics or opinions, or you have postage stamp-sized free speech zones that restrict dialogue to the corners of campus, you're diminishing that competition of ideas. You're denying the university community what Mill called the clearer perception and livelier impression of truth produced by its collision with error. And you're mutating that search for truth into a holy war of ideology. Our model bill is informed by what the U.S. Supreme Court has said about the importance of free expression on college campuses. The court has said that the college classroom with its surrounding environs is peculiarly the marketplace of ideas, that there is no room in the court's precedents for the view that because of the acknowledged need for order, First Amendment protection should apply with less force on college campuses than in the community at large. Quite to the contrary, the village and protection of constitutional freedoms is nowhere more vital than in the community of American schools. And that's why our bill restricts the university's authority to limit speech and requires the university to use its authority in an even-handed way to protect those constitutional freedoms and the values that they serve. And I think it reflects the duty that I was talking about earlier about the legislature's duty to enforce the protections in the state and federal constitutions. So how do we do that? Our bill allows for time, place, and manner regulations that focus on the when, where, and how of campus speech, but quite deliberately prohibit any consideration of the who or what. And these regulations that we allow under the bill are more stringent than the courts allow currently. The regulations have to be reasonable, they have to be viewpoint and content neutral, they have to be necessary to achieve a compelling institutional interest. It's not just helpful, but actually, factually, evidentiarily necessary. They have to be clear and published so that people know what the rules are, and they have to provide ample alternative means for expression. And they require that the public areas of campus are treated as public forums, open to the same terms, on the same terms to any speaker. Essentially, if you have a right to be there, you have a right to speak. And this will clarify the standard that courts apply to university speech codes, hopefully making it simpler and is certainly making it more protective of free expression on campus. But still allowing regulations that are actually necessary to prevent disruption of the university and ensuring that all publicly accessible areas of the campus are open to all speakers on the same terms. As I said, those regulations go, those restrictions on regulations go beyond what courts have held are the bare minimum requirements of the U.S. Constitution. And in some states, the state constitution will require more robust protections, even in the absence of the model bill. I'll give you an example of where I think the courts have drawn the line incorrectly and where our model bill helps to redraw the line. So one court has held that, has upheld a university policy that allowed certain candidates for student government and no other students to solicit door-to-door in student dorms because the uneven band furthered the responsible and effective participation in student government political activity. But the Supreme Court has made clear that in recent cases that the lodestar of First Amendment protections is content neutrality. So regulation of speech must be even-handed, regardless of the message. And our model bill embraces that more protective, content-neutral view of free speech rights. So to take the example of the dorm room solicitation, the university still has the authority under our bill to ban dorm room solicitation if it were demonstrated that it needs to do that to prevent disruptions, or to limit solicitation to certain times or dates. But it has to treat all speakers the same, regardless of their message. Essentially, speech is speech, no matter the content. So what do we do about conflicts? We've talked about shout-downs, and that's a key part of our bill. And one of the things that we felt that current solutions to the free speech problem weren't really addressing the shout-down problem. It's important that when there are conflicts between speakers that they're resolved in an equitable way. So when protesters shout down an invited speaker, it can look like a conflict of rights. The speaker and the students who invited that speaker on the one hand, and then the protesters on the other. And in fact, I'll argue that there is no conflict between rights. The protesters have no right to speak if their aim is to silence someone else. If the speech of the protesters is the equivalent to holding a bullhorn in someone's face and preventing them from speaking, it is not protected expression. And so when the suppression of ideas rather than dialogue is the result, then what we've learned is that discipline is necessary to send the message that incivility will not be tolerated on university campuses because it is at odds with the truth-seeking mission of the university. And we know discipline works. Professor Thompson talked about this yesterday, the 1974 incident when eugenicist William Shockley was shouted down at Yale and frankly saved from the embarrassment of defending his ideas in a debate. And out of that came the Woodward Report, which is a key influence on our model legislation. And of course, the Woodward Report eloquently upholds the value of free expression and insists that students who shouted down visiting speakers must be disciplined. And the Woodward Report establishes a sanctions policy and establishes a system for warning potentially disruptive students about the disciplinary consequences. But that lesson that discipline is necessary for for students who disrupt the free exchange of ideas is a hard lesson for universities to learn and to follow, because it's easier, it's politically expedient to just stand on the sidelines, as administrators did at the University of Michigan when a debate about the tactics of the Black Lives Matter movement, just a debate about the tactics, mind you, not the movement itself, was shouted down, and administrators did nothing. In fact, one of the students who organized and praised the shout down was awarded with a special commendation by the university. And so because of that level of commitment to discipline, we've seen shout downs on and off ever since, with a string of these incidents recently, I think aided and abetted by speech codes that have taught students to be more concerned with feelings than intellectual forthrightness. And the 2016-2017 academic year was called by my co-author Stanley Kurtz the year of the shout down, where he cataloged at least one shout down a month at various college campuses. Some of the folks in this room are on that list. Punctuated, however, by one shout down that didn't happen. Katie Pavlich is a Second Amendment advocate, writes for Town Hall. And she was giving a talk at the University of Wisconsin about gun rights. And students came to protest, and I won't repeat their slogan because part of the right of free expression is the right to not speak. But it's a rhyming alternative to the Glock handgun, and that they suggested that students get their hands around that rather than a gun. Some of you got it. So, but they showed up, they did their protest with this silly thing, this silly phrase, and but they didn't shout down the event. They didn't disrupt the event. They got their ideas out, and some reporters came up to them and asked them why they were there, what they were going to accomplish, and they explained, we thought about shouting down the event and stopping it from happening, but the University of Wisconsin has just adopted this policy that if we're twice convicted of or found responsible for interfering with a planned event, that will be suspended, and if we do it 3 times, we'll be expelled. And so we decided instead we're going to have a peaceful protest here. They got their ideas out. Katie was allowed to talk. That's what we're trying to achieve, and that's why we think having this this suspension policy, which is a key part of our model bill, is both just and effective. There's really no excuse for shouting down a speaker in the first place, but if you've already been found responsible for doing it once, and you do it again, then clearly the lesson has not been learned. And of course, the Woodward report called for suspension or expulsion after a single offense, and our model bill only calls for it after repeated offenses. And our model bill requires that policy be explained from the very beginning of freshman orientation. There is a discussion with the incoming freshman about the value of free expression. And I know that's something that at least the University of Arizona does, and I assume that the Arizona State does as well, is to talk to students about why free expression is important and why tolerating other people's views and having intellectual discussion is the path to truth-seeking. So, as I said, if we're to determine this line between where one speaker's rights end and another's begin, we need an impartial process. And so, in including discipline in our bill, we've also included robust due process protections. Due process on campus has been a travesty for decades, in part because the courts have been willing to give administrators too much leeway to define due process, and in part because of the legislature deputizing administrators to do the work of law enforcement, as in sexual assault investigations. So for the speech context, and this could be adapted more broadly, but for the speech context, our model bill calls for the most robust due process protections, coupled with, of course, those penalties designed to deter the heckler's veto. Are we doing that? Just 2 minutes? Okay. So I won't go through all of that, all of the individual parts of the due process protections. But the final thing I'll say is that the bill gives all of these protections and restrictions some teeth by authorizing citizens to sue to enforce its provisions. This is a lesson that we've learned through decades of public interest litigation, is that laws like this are weapons, not shields. And when legal protections are ignored, individuals need to be assured that they will have a clear path to enforce their rights in a court of law. And this is, of course, a deterrent as well, because administrators know that about the risk of litigation, and it looms over every free speech decision that they consider. And so the safe thing to do to avoid litigation is to allow more speech, not less. And deterrence is also the primary reason that we've included an attorney fee provision. It's not so that I can cash checks. It's to deter administrators from violating the law in the first place. And deterrence is also the primary reason that we've included an annual report that catalogs the free speech instance on campus. It does the hard work that FIRE has been doing for so many years to try to get a handle on what exactly is going on university campuses. And it requires the universities to play an active role in that and report to the public and the legislature the state of free speech on campus. Once students believe that there will be real consequences for suppressing the speech of others, and administrators believe that there will be real consequences for looking the other way, the shout-downs will stop. This system that we've put in place with this model bill is designed not to punish protesters, but to prevent the need for discipline in the first place by incentivizing civility. And if you want to learn more about the model bill, you can go to restorefreespeech.com and read the white paper and model bill, and also check out the really slick video that we put together explaining more about it. Thank you.
So I want to speak in specifics here as much as possible, because in a lot of things the devil is in the details. First, the big picture thing. This is the Arizona State University. It's a state university. I teach at the University of California. Not an accident about the name. It's run by the state. It's funded by the state. I don't think there's any inherent reason why the university should have independence from the state legislature. In some states, in my own California, there's some case law for the proposition that the state constitution does indeed set this up, to give the university considerable autonomy. It's a possible theory as a matter of state constitutional law, but certainly as a First Amendment matter, I don't think there's any problem. At the same time, not all micromanagement is a good idea, and not even all mid-level meso-management perhaps is a good idea. There are a lot of things that are worth leaving for the principal to leave to the agents. And the question with any such regulations is, does it make sense? I think on balance, the proposals that we've heard outlined are a pretty sensible idea. Among other things, they involve some things that are mandated by the First Amendment in any case, but are worth restating. Some things that are legislative choices about how to allocate scarce resources, and it seems to me the legislature that provides those resources might make them reasonable. I will get to that in a moment. One difficulty, of course, is whenever you try to codify something, take a complicated legal principle and turn it into a statute, there's always the danger that you'll get something wrong or something too rigid. That's one objection. There was a big codification movement in the 1800s. Turns out that even simple things like the law of homicide is actually pretty difficult to codify. Thou shalt not kill, let me just tell you, that doesn't do the job. And anything beyond that ends up being pretty complicated and also sometimes too rigid in light of future changes. Certainly we wouldn't want the legislature to codify things that are outside of its expertise, like even setting aside politics. So the legislature wanted to set the curriculum for a calculus class. I think that would be a bad idea. But I think when it comes to protection for college student speech, I think it's a sensible idea, especially if it's limited to public universities, which are run by the legislature. Restrictions on private universities are a more complicated question. California is the one state that does impose such restrictions. You can argue for or against them, but that we don't need to talk about them here. Now, it's important to think that to consider the various functions of these sorts of proposals, because there are multiple functions. One is to set up legally binding rules enforceable by courts. One thing is, even with the attorney fee provision, it probably won't be the main way it's actually works, because lawsuits are going to be relatively few and far between, as they should. Second one is this deterrent effect. Set up legally binding rules affecting people who don't want to end up in court. But again, we shouldn't focus just on that, because sometimes you have rules that you realize courts are not going to enforce in any rigorous way, but are still potentially useful. One thing is legally binding rules that offer support for administrators who want to follow the rules all along. Now, not all administrators are this way, but I think there are probably quite a few administrators who, even if there's not going to be any lawsuit about this, in part because of their decision, want to decide in favor of student free speech. They're feeling some political heat from some constituency, and it's helpful for them to say, look, the statute calls for this. If you don't like it, take it up with the legislature. I think that's a pretty useful function of a lot of these kinds of things. Another thing is a focal point for decision makers who are trying to get things done. It happens all the time. You're in a committee, and you don't really want to be on the committee. It's not your goal in life to be on the maximum number of committees. You need to figure out kind of what policy to have or how to enforce things. You look to things, even things that aren't legally binding, you look to them as guidelines that, well, you know, maybe let's just start from this and use it as a basis for joint decision making. There are also reference points for critics of universities. It's a lot easier to hold universities to hold their feet to the fire if there are particular objective rules that their supervisors in the legislature have announced. To be sure, some universities would say, we don't care what the legislature says. But few of them, for various reasons, do. So even if they end up never going to court, having this kind of reference point is useful. And finally, they may have some degree of influence on citizens, faculty, and students who look at them. And this is what Gerard Jelinek once called the normative power of the actual. They look at the rules as they are, and they come to absorb them as the rules they ought to be. Are these going to be guaranteed effects? By no means. They're not going to be universal either. But potentially they're quite useful. This is why I think the project is a good idea in general. Let me then quickly go through each element of this project. So one is the first provision in the, I'm going to mostly talk about the Goldwater proposal, but I'll also talk at times about the specific Arizona bill in those places where it differs. Students and faculty have the freedom to discuss any problem that presents itself, as the First Amendment permits, so recognizing there are going to be some exceptions, and within the limits of reasonable viewpoint and content-neutral restrictions on time, place, and manner of expression that are consistent with this act and are necessary to achieve a compelling institutional interest. And then there's a procedural requirement that the restrictions must be published, must be clear, and must provide ample alternative means of expression. So this is all borrowed from First Amendment law, but, and I think the Goldwater will agree, it is actually a broadening beyond the First Amendment rules. When it comes to a lot of the property on campus, it is probably property in which the requirement is only viewpoint neutrality and not content neutrality. Just to give an example, I suspect that a university could say, not that it probably would want to, but it could say in either, well, let's take particularly in the dorms. In discussions in the dorms, you cannot use vulgarities. And if you do, you can be disciplined in some measure. That would be an example of a content-based but viewpoint-neutral restriction, so long as it's enforced in a viewpoint-neutral way. This statute would preclude that. Maybe a good idea. It may be that, in fact, the number of content-based but viewpoint-neutral restrictions that you would want to have a university, as opposed to, say, in a courthouse or some such, is actually pretty narrow, and we can dispense with them. Another thing, though, that I'm wondering about is, let's say somebody wants to have a demonstration or a protest, not in the quad, but in the hallways of the law school, of this very institution. Under First Amendment law, it's almost certain they can't, because these hallways would be a non-public forum, where, again, viewpoint-based classifications are impermissible, but content-based and content-neutral ones are allowed so long as they're reasonable. This would raise the legal standard to so-called strict scrutiny necessary to achieve a compelling institutional interest, deliberately a very hard standard to meet. Now, to be sure, if the protest is loud and interferes with teaching or blocks the hallways, then in that case, that might be restrictable. But absent that, even if it just kind of makes the hallways a little harder to navigate or kind of creates an environment that doesn't seem conducive to learning and paying attention, I'm not sure that a restriction on that would be necessary to achieve a compelling institutional interest, as opposed to merely legitimate or merely reasonable. Again, on balance, I'm not sure that that's that bad. It may be that this law protects speech more than it has to be protected, but in these examples you might say, well, if somebody wants to have a protest out there, so long as it's quiet and so long as the hallways aren't blocked, fine, let them go ahead. But it's worth keeping in mind that it indeed, as again was acknowledged and praised, actually goes beyond First Amendment. The one other concern, though, that I have is that nothing in this section excludes the classroom. So it makes me wonder what happens to restrictions that I impose on my students. One of them might be, if you say certain things that are rude, I'll stop calling on you. It'll take a lot of rudeness for me to actually try to get you expelled. But if I find that you're routinely insulting to your classmates, I'll stop calling them. I have to say I never had to do this. Maybe because people assume that I would do something about this if push came to shove. I'm not sure that that would be permissible here, because it sounds like that would be a content-based restriction. Now, this may be one of those examples that eventually, when it comes to court, the court will read it in a way that somehow avoids that. But that's one possible danger. I'm not sure that was a deliberate decision of the Goldwater Institute, but one danger of codifying, that you might end up covering things you don't expect. Now, what about outside speakers? Outside speakers also deliberately given more rights. And a lot of universities can, if they want to, exclude outside speakers altogether. We saw some reference to that. This rule provides that outside speakers actually have to be allowed down to protests and demonstrations, so long as they don't materially and substantially infringe on the rights of others. So that means if somebody wants to hold a political rally, as to matters completely unrelated to campus, but just, we want to hold the latest political rally, we want to do it in the quad, the university can't say, no, we don't like you having rallies in the quad because this is for our students to sit and enjoy lunch. And students can have rallies because that's part of the educational experience, but we don't want you to have them. This statute would prohibit that. And it's not necessarily a problem. It could be one of those decisions that the university could make one way or the other. And in this instance, the bosses of the university say, hey, this property, this quad was paid for by taxpayer money. It's supported using the funds of all the taxpayers and not just the students, although students do these days pay a greater share of this, and therefore we will allow this. It's an interesting experiment, but again, note this does indeed provide more protection than the First Amendment requires and diminishes in some measure universities' flexibility to kind of provide a somewhat more peaceful environment for students. There is an exception, by the way, here for maintaining order in the classroom. I very much appreciate that. But again, note this is an exception in the section having to do with outside speakers. That's why I worry a little bit that the previous section, which lacks such an exception, might have unintended consequences when it comes to the classroom. The next section talks about protecting speaker safety. And here, I think this is quite right. But note that it too makes a deliberate choice in a way that at least there may be some flexibility on universities' part otherwise to make the other way. Institutions shall make all reasonable efforts and make available all reasonable resources to ensure the safety of invited speakers. Institutions shall not charge security fees based on the content of speech or content of speakers. I think that's probably the First Amendment rule already, though not completely obvious in so-called limited public fora like most universities are. Viewpoint discrimination would be forbidden, but the content discrimination not quite as clear. This would prohibit that. Institution may restrict the use of its non-public facilities to invited individuals. That makes a lot of sense. That even if you can have a rally in the quad doesn't mean you can demand access to classrooms or lecture halls. It seems to me that if you look at the text, it's deliberately quite vague. All reasonable efforts and all reasonable resources. Maybe this is one of those situations where judicial enforcement isn't going to get you that much, although courts might try to draw reasonableness lines. I suspect they're going to defer to legislative judgment. But this might be a situation where having such a policy out there that's set up by the legislature and that eventually is adopted by universities may be a useful focal point for discussion. That when somebody says, why should we protect this person? People could say, look, it does say in the statute we have to make reasonable efforts. So let's reasonably talk about what's a reasonable effort and use that as the starting point for discussion rather than spending time debating whether you should even have any such protection. Punishment for disruptors, I think that is, I need to synchronize my version and that version. That is something that is specifically a legislative decision. I think, again, a good one, but It's a judgment call as to what kind of punishments you should have. Note the second sentence specifically says that any student who's twice been found responsible for infringing the expressive rights of others will be suspended for a minimum of 1 year or expelled. Those of you who like to draw connections to other areas will recognize this as closely linked to this big debate we have about mandatory minimums and zero tolerance policies. Mandatory minimums in criminal penalties, zero tolerance policies often in K through 12 schools. The common aspect of this debate is how much does the boss trust his subordinates? If you trust your employees, your bureaucrats, if you want to use a negative term, then you might say, look, or judges, we'll leave you flexibility, because flexibility is often called for. Different kinds of disruptions of different magnitude, different kinds of deterrents are necessary in different kinds of cases. We'll trust you. And for example, historically, we'll trust the judge to try to tailor the sentence very much to the facts of the crime. There's basically used to be indeterminate sentencing where you could have judge sentence someone anything from 0 to 20 years. And then have a lot of flexibility. Then what happened is people stopped trusting judges, whether rightly or wrongly, it's not clear. The fact that a few judges make mistakes or a few principals make mistakes doesn't mean that you should straitjacket all of them, but if enough make mistakes, maybe you should. So this bill, I think, reflects mistrust of administrators. Maybe well-placed mistrust, but again, it's important to recognize this judgment. It's important also to recognize one cost of this judgment, which is if you tell an administrator that any time a student has been twice found responsible for infringing expressive rights of others, he's got to be suspended for a year. That's a huge interference with a person's life. If the administrator might think that that's unwarranted, whether because the administrator is a softie or sympathizes with the person, or really is soundly judging that it's unwarranted, maybe the administrator will be tempted to say, oh, this wasn't really a violation. This is one criticism people made against very harsh driving under the influence penalties back when there wasn't as much social consensus against DUI, is if you say anybody who is sentenced for DUI will go to prison for X years, a lot of juries will just acquit rather than finding guilty, even if the person's guilty. Note the Arizona legislature, at least at this point, seems to trust administrators more, at least be unwilling to announce its distrust. It's leaving deliberately things more closely, more to the, in fact, entirely to administrators. Interesting question, what's the right answer? Maybe there's some other compromise which is twice been found responsible, suspended for a minimum of a month or a quarter. You know, that actually is a pretty significant penalty as well. The Arizona bill also provides a definition of disruption. Basically, something that materially and substantially interferes, but specifically talks about fighting or violent behavior, protracted commotion, utterance, or similar action, or physical blocking. You can tell some of it is pretty vague, right? Commotion, utterance, or similar action. Although that might just be inherent vagueness, my father sometimes says, when I complain about vagueness of someone who says it's vague as life itself. Oh, I'm sorry, thank you, thanks very much. It's as vague as life itself. So it's an interesting question. Maybe this is one of those things that in fact will end up not something that courts will define very closely, but might have some useful value as a focal point for internal discussions. Let me just close with the due process discussion. Here is something where the constitutional rules are very far from clear, very far from settled, much less so than in the First Amendment area. And this is either really a valuable contribution or a harmful straitjacket. I'm inclined more to the former view, but again, it's really worth understanding what's going on here. It's got to be advanced written notice and review of the evidence in support of the charges. That's good, but confronting witnesses against them. That's a hallmark of the criminal justice process and civil justice as well. But not all processes that we run operate this way. If you run a business and a couple of customers accuse your employee of rudeness to them, you're not going to say, well, I can't fire the employee. I can't even discipline the employee until I bring the customers in and have him cross-examine them. You're not going to say that. No, it's like, look, if 3 people have accused you of rudeness, even if they're anonymous, even if I don't know who they are, certainly I'm not going to bring them in. That's good enough for me to say, I don't want you out there representing me. Maybe that's the wrong model for students, but it's important to realize that there are different models we use in criminal and civil justice versus employment. It's an interesting question where student restrictions on students should fit into that, especially as to someone more burdensome, things like confronting a witness. Presenting a defense, I think that's got to be right. Calling a witness, impartial arbiter, or panel, I think also a good idea. Note the active assistance of counsel. I think what this calls for is assistance of counsel in the form of if the student wants to hire a lawyer. Oops, oh, I'm sorry. If the student wants to hire a lawyer, they can hire a lawyer. But I suspect what's going to happen pretty quickly is people say, well, that's hardly fair. A lot of our students can't afford to hire a lawyer. So while obviously the Sixth Amendment right to counsel doesn't apply here, and likewise not the right to appointed counsel, I suspect at some point there'll be pressure to provide, for the university to provide lawyers. That is going to be pretty expensive. Trust me, I'm a lawyer. And an interesting question, by the way. Maybe ASU should have the law school maybe should have a little clinic whose job it is to provide these kinds of assistance in this situation. So on balance, I think it's a very worthwhile effort. I might have drafted things a little differently, but the basic point I want to say is for these things, the devil is in the details. These are actually pretty good details, the detailed drafting. But I think it needs to be talked about as to the particular rules that are being set forth, and not just in the abstract.
Thank you. We have time left over for some questions.
So this is a little bit embarrassing watching this legislative enterprise to try and ensure that speakers are heard in silence. I wanted really to ask James and maybe Eugene too, a little bit about the legislative proposals. Is there provision in the proposals to exempt from the shouting down penalties and the threat of suspension somebody who has just shouted a single comment, whether or not that comment is then followed by cacophony or commotion in the more orchestrated sense? Because my impression is that no matter how you draft this, unless you include some specific exemption from this, you're going to find university authorities going for the low-hanging fruit. The person, maybe smart-ass Waldron, who stands up at a speech and shouts out some comment because a lie has been told or a relevant fact omitted or some manipulation, shouts that out, and maybe by his example encourages others to shout things out, and people will say, well, this utterance has caused a commotion, and in order to protect the, I think, cowardice of speakers in this country who can't think on their feet and are incapable of responding with any flexibility to comments, we're going to end up trying to promote, or effectively promoting, a rather cowed and silenced generation when we should be thinking about the activity, not just the passivity of student minds. So do you have any possibility of making provision for that, for the solitary interrupter, irrespective of whether there are other interrupters or not?
Yeah, three thoughts on that. And Eugene, if I could impose on you to cycle to the definition of disruption.
Right, that's in the Arizona bill. Yeah, that was going to be the next slide, but I'm happy to put it up here.
So first of all, I will admit that I have more sympathy for the questioners than the presenter last night, although I think you make an excellent point about the value of tough questions. And I think what it boils down to is just a question of civility and decorum. What are the rules of the forum? And typically in a situation like this, the rule is that the questioners wait until the end and then ask the tough questions, which you've done, which is fantastic. And that's, so I guess to the first point is, if that heckler can't heckle anymore, oh well, it doesn't really keep me up at night. As long as we have the opportunity to ask tough questions at the end or afterwards or wherever else. I think civility is an important value. The definition includes materially and substantially interfering, and then is more detailed in the Arizona bill with the protracted commotion or utterance. So I don't think that actually that legitimately that what the scenario that you're proposing would fit in that definition. It would not materially and substantially, the utterance itself materially and substantially interfere, nor would it be protracted. And to answer that question, we have the due process protections in place that don't exist on most university campuses. To ask that question, an impartial panel will decide whether the heckler has done that or not. And as I say, I think in the strict scenario that you're presenting, I would probably vote no if I was on that panel.
Yeah, I think that's right. The definitions, again, are necessarily not completely precise, but it does require material interference. It requires substantial interference. It requires that a person, it's got to be conduct by a person. So absent some evidence of a conspiracy, you can't hold people liable for what others say. It has to consist of a protracted commotion or utterance. So I think definitionally it wouldn't include the single incident.
So protracted goes with utterance as well as commotion, is that?
Yes, I think that's right. It's an interesting question. I mean, it's a classic question of statutory construction. I used to be a computer programmer. That was my first career. I love parentheses in computer language. Right? You say protected, parent, commotion, utterance, or similar action, close parent. But it seems pretty clear that that's what would have to be. So, although I'm sure it would be taken as a friendly amendment if you were to say the bill should say protected commotion, comma, protracted utterance, or similar protracted action. I will say, though, more broadly, one thing that I think this bill is attentive to is this point that was raised by Professor, I want to make sure that I have his pronunciation right. Is he Weinstein? Is that?
Both of Weinstein.
Okay, but I know that there's this uncertainty. So in any case, the other Professor Weinstein, the bearded Professor Weinstein, that you have to think about this in evolutionary ways. That you have to look at the pressures that are being that are operating in the competition between various life forms. And here you have in-person speeches competing with lots of other ways of getting information. So if you have a situation where there's an incentive given for people to basically shout down speakers, because I think in the aggregate without something like this there's going to be lots of that, and as one group sees it working, other groups will do the same. The consequence will just be you'll have a lot less invited speakers, at least on any controversial topic, and people will be left to YouTube videos or to Twitter. Is that an improvement? I don't think so. So that's why I think that on this point, I think the bill is actually a very worthwhile step forward.
Okay, so my question is on a matter that was brought up last time, and I was mildly surprised it hadn't been brought up for this one, but I think it's very relevant, though I hope you won't mind me bringing the question of government policy to the national level, in that I would like to talk about Title IX. So it has been to my knowledge that Title IX and the subsequent expansions of it by the judiciary over the years has directly been the cause of many restrictive speech codes over the years. I know fire, for one, has taken a great deal of trouble with Title IX and how it's been interpreted. So, and that's not to say it hasn't done good as well. I don't want to be entirely dismissive of it. But considering the great deal of complexity that has gone into it, such as its original expansion from anti-discrimination into covering how the university must handle sexual assault, in addition to the subsequent control of it by the executive branch, as we've seen Obama's hard line against universities and the use of preponderance of evidence, whereas Trump has now changed it to a softer line, and the use of clear and convincing in university hearings. I wanted to know what you all would think would be the best solution to the issues around Title IX, and how you think we could best handle the issues with regards to having adequate protections for students.
So let me give a first crack at this part, because I've actually originally
Please correct me if any of that was wrong.
Sure. Well, closely related question. So there are a few things going on here. One has to do with Title IX and sexual assault. That's just not an issue that we've discussed here, although it's a very interesting question. I'll get to one aspect of that shortly. A second has to do with whether Title IX mandates the creation of campus speech codes. I think as a general matter that's a misinterpretation of Title IX. I think that would be an unconstitutional interpretation of Title IX. And I think to its credit, this bill, and this is the second point, this bill I think tries to consider that, but in a slide that I cut for time reasons, when it lists the exceptions, it has an exception for harassment, but I think on balance a relatively sound one, although one can quarrel with certain details. and that is for targeted harassment, essentially, of individual students. That's my paraphrase. But what it essentially says is if somebody is deliberately going after a particular person and talking to this person, kind of constantly calling them by epithets, or you could imagine some situations, people talk about hate speech, this could be a love speech, going after somebody and asking them for dates after they've already said no. Title VII generally has been read as requiring employers to restrict that. You could imagine university doing that as well, again, because it's targeted to a particular student. The view of this bill, which I think is correct, is that Title IX should not be read as prohibiting speech that is perceived as sexist or racist or religiously bigoted or whatever else that is said to the public at large. Where basically somebody, for example, says, I think Islam is a horrible religion and I think Muslims are bad for the following reasons, or the same thing about conservative Christians, or the same thing about Catholics, or the same thing about various racial groups, or either sex or whatever else. So I think that this bill takes the view, or this proposal takes the view, that Title IX cannot be viewed as a general purpose speech code, and that at most bars this targeted harassment and so-called quid pro quo harassment, sexual extortion essentially, sleep with me or I'll fire you, sleep with me or I'll give you a bad grade or something like that. The last thing I want to say, since this issue came up, I think people are interested in it, is the preponderance of the evidence versus clear and convincing evidence rule. Again, I think it's important to realize that we're used to proof beyond a reasonable doubt in criminal cases. But that's not the only rule out there. In fact, it's the rule only in criminal cases. Clear and convincing evidence is the rule in a few cases, like punitive damages generally, and also professional licensing decisions. You can't get my bar card pulled without clear and convincing evidence. But in a lot of situations, such as civil liability, people can be financially ruined through a damages verdict based on a finding of mere preponderance of the evidence. And again, in the employment context, you can imagine some employers, including some public employers, saying, look, I think there's only a 30% chance you're guilty of this, but that's enough for me to fire you and replace you with someone for whom I think there's only a 0% chance or a 3% chance of that. You could imagine a public daycare place saying, you know, we've investigated charges of sexual molestation on your part, and we think that probably you're not guilty, but better safe than sorry. There's no constitutional barrier to that. And certainly I think that's the norm in many private workplaces. So whether you apply preponderance of the evidence or clear and convincing evidence is actually a complicated question. Here's what I think is the strongest case for applying clear and convincing evidence. Expelling somebody, so this would be sensitive to the magnitude of the punishment. Expelling somebody is so damaging to their life that we view it as even more damaging than being fired, let's say from a job, and comparable to losing a professional license. Because in a sense, sometimes it's kind of anticipatorily. You can't even get a professional license if you're expelled, especially if other universities won't let you in. So that could be a reason for serious enough penalties to mandate a clear and convincing evidence standard, although I think it's understandable that this bill does not actually do that. Last question.
One last question.
Briefly, Eugene, I understood you to be engaging in an exercise of showing some of the risks of codification.
Right.
Right. So this reminds me of sort of the ancient critical legal studies polarity between standards and rules. Are we better off with no codification?
Mm-hmm.
Would you rather have unlimited discretion on the part of universities or any other decision-making body without any kind of effort to give notice to the relevant parties as to how they're going to behave? So obviously there's risks in codification, but there's also risks in non-codification.
Totally, which is why, again, on balance, I think this is a good effort. I think one reason to keep in mind the risk of codification is just to be very careful. I think the Goldwater Institute was very careful. I think maybe that there are places where it could have been more careful, for example, in making clear that the students and faculty rights don't extend the same way to inside the classroom, which is an area where I could imagine there being some unnecessary controversy. I think the answers to whether codification is a good or a bad idea I think varies sharply from different situations. So for example, I would hate to have a statute that codifies what the criteria are for deciding whether someone gets tenure, other than the familiar ones of excellence in research, teaching, and service, which really means excellence in research, decent teaching, and no utter failure in service. That's the reality. I'm not saying it's normative, but it's the way it is. Because I just don't think there is a reasonable codification to the contrary. Likewise, I'll tell you, turns out federal criminal law has not codified the defenses. So there's no self-defense statute under federal criminal law. You can raise the self-defense defense, but it's all common law. It's all a matter of judge-made law. In part because I think Congress trusts judges on that. Maybe judges are trustworthy as college administrators or not, but these are decisions to be made. One other example is, I would hate to see codification about the rules of when I could tell a student, look, I'm not going to call on you anymore because you're being rude or off topic, or sometimes even you ask questions that are really fantastic questions, but they're way beyond what I'm trying to teach right now. Maybe because a lot less is at stake, maybe it's a lot harder thing. So I applaud this because I think this is an area where good codification is a good idea, but we can't always take the view that it's either always good or always bad. Let me just return to one last thing. Note the one area where the Arizona legislature didn't quite agree as to the codification is with the judgment about the magnitude of the sentence. That the proposal essentially comes up with a bright line mandatory minimum. And the legislature says no, or at least the current version of the bill, no, we want to leave it to administrators. Maybe that's right, maybe that's wrong, but I think it's an example of where reasonable minds can very much differ about whether we want to have this kind of codification because we don't trust the administrators and we think a bright line rule is good, or we don't because the bright line rule we think is just going to be too imprecise and better leave it to administrators.
Let me just say on this one, here's something you can take to the bank with you. If you have a code, there will be times when the code seems too rigid. There'll be some, a miscarriage because of that, and people will want to go to standards. And then when you have standards, there will be miscarriages, and they'll want to go to codes.
Always.
So the grass is always greener, whether you're with codes or with your standards.
Right.
And one point of clarification, just to put all of the college professors in the room at ease. The provision,
should we be at ease?
Well, at least in this respect, some small respect. The provision that restricts that limits the applicability of the bill to not preventing professors from keeping order in their classroom. The way that the bill is written, the model bill is written, all of these are provisions that the university would adopt in a policy on free expression. These are sort of the bare minimum, and that limitation applies to everything. So, and Arizona may have muddled that a little bit. But I assure you that is the intention.
Well, I'm glad to hear that. That's not how I read it, but maybe I misread it.
That's also not how our general counsel read it. It was Puerto Rican, so
Well, we should talk about it.
Okay, thank you, everybody.
Join me in thanking Sandra. Knowing that the Board of Regents member is here, we have Eileen, we have the President of the Board of Regents at our opening dinner. So I have a few closing remarks to all the students who are still here and everyone here. We have a very active, busy website, constantly updated, full of information, so please stay in touch with the school. Students should know we do have a curriculum, we have a minor, we expect to have a good vote next week in the University Senate, have our major approved. We have 2 more events in this year-long speaker series on free speech and intellectual diversity. So whether you're near or far, we hope you'll stay in touch with the school and stay involved. My thanks to all the speakers across these 3 days who came from near and from far. We're delighted with the range of viewpoints we had, addressing a range of important topics and the very high level of discourse we had throughout. And we're very much looking forward to what Jim Stoner and I can come up with as a published volume coming from all this. I do have final thanks to give, as it lists on the front of the program, our partners, our sponsors, The organizing committee, single out, again, Dr. Carol McNamara, our Associate Director of Public Programs, and also her the staff that has organized this whole event. Melissa, Ty, Kim, Gayla, Susan, Diana, and our student workers. I'm sure I've forgotten folks. Thanks to Arizona PBS, who's here recording, and again, the video will be up on our website of the full conference sessions, and then look for the edited version coming from Arizona PBS. So with that, thank you very much for being here. One last round of thanks for our panel.